Good afternoon, everyone, and thank you for sharing your lunchtime with us. I know there's a few people in the audience that I know, and so thank you for everybody for coming along today. In case you don't know me, my name is Andrew Grima. I'm a partner in the property team here at Bardia Perry. My focus is on property transactions, being a property partner. So I do anything. I like to say to people, and Emma would attest this, anything to do with dirt, a piece of dirt, and usually with something built upon it. It could be buying, selling, leasing. It can be residential, it can be commercial, it can be a big office tower, it can be a factory, it can be a small corner shop, it could be someone's investment property or their holiday home. I basically do property transactions. But often my world intersects with my colleague Emma, who is in commercial disputes. So I'd like to introduce you to Emma.
Good afternoon, everyone. I'm Emma Boyce, a special counsel in Bardia Perry's commercial disputes team. I run a broad disputes practice, but as Andrew mentioned, a significant part of my work is property disputes. And importantly, I work very closely with Andrew and his team on matters that sit at the intersection of disputes and transactions. What differentiates my practice is that I try to be involved before parties become very entrenched. So by working alongside our transaction lawyers early, we can usually de-escalate issues, resolve them commercially, and without the matter needing to tip into formal litigation. By being involved at that point, I find that we can usually resolve issues commercially and avoid a full-blown litigation, which is almost always faster, cheaper, and far better aligned with what our clients actually want.
Absolutely.
So for today, just a bit of housekeeping. We have 1 hour to talk about today's topic of managing risk in leasing, conveyancing, and security enforcement. So the roadmap of today's presentation is that we'll firstly spend about 15 minutes discussing leases and common disputes that can occur in respect to leases. Next, we'll spend about 15 minutes discussing conveyancing transactions and some tips for avoiding common disputes and traps that can lead to conveyancing transactions being delayed or worse, litigated. We will then spend about 15 minutes discussing enforcement of different security you might have in a property, the benefits of different forms of security, and the things to avoid. We should then have about 15 minutes for Q&A, but that will depend on how many war stories Andrew shares with us. While today we'll focus the position in New South Wales, Andrew and I work across all jurisdictions, and each state has different rules and regulations, in particular around retail leases. So just keep in mind that what we're talking about today is the New South Wales rules, largely. We have the chat function enabled throughout the presentation. So if you think of a question while we're discussing, please feel free to put that question into the chat box, and we will address it during the Q&A portion. We'll also send an email around to all participants following the presentation asking for feedback. So if you think of a question then, feel free to put that question in the feedback and we can come back to you. You can also reach out to Andrew and I directly, and our email addresses can be found on the Bardia Perry website. So we might kick things off with all things leasing. Andrew, a large part of your practice is around both commercial and retail leases, as you mentioned earlier. Can you tell me a bit about commercial and retail leases?
Yeah, so first of all, I'll talk to you about the distinction, right? So in the marketplace, when we're talking about a commercial lease, that can mean either an office lease, for example, or it can mean an industrial warehouse type lease. And we loosely put them both under commercial, but sometimes in the real estate industry, there'll be a distinction between a commercial and an industrial lease. But for the purpose of this discussion, that is what a commercial lease is. Versus a retail lease is a lease, I'll classify it as a lease governed by the Retail Leases Act. Now, in New South Wales, and I'll try to keep this as user-friendly as I can. In New South Wales, there's a broad definition of what a retail lease is. And just as Emma said, in each state and territory, there's a different retail leases regime that has a slightly different definition and terminology to work out whether it's a retail lease or not. But in New South Wales, a lease is governed by the Retail Leases Act if either it fits within a shopping list of particular uses referred to in the Act, and it can and it can be and there's a number of them. And say, for example, back in 23, there was amendment. Say, for example, now a gym, a Pilates studio, or a small bar can be considered a retail lease. And so, for example, you'll see across the industrial parks of Greater Sydney, you'll see a gym pop up or a Pilates studio pop up, even though it's not in a shop. It's going to be, and you think, oh, it's an industrial shed. That could be governed by the Retail Leases Act. That's one way. Or the other way is it may not fit within the shopping list, but it's in what we call a shopping centre. And a shopping centre is where there's a cluster of 5 or more retail shops within a building, or it could be like in an arcade setup.
Yeah, so that's like our big Westfields and stuff.
Absolutely, or your local
supermarkets.
Yeah. Correct. Yeah. And there are exemptions. So depending on size of footprint or term, there could be some carve-outs as well. But the reason that there is a difference, and you see that when you see the disputes come up, which we'll go into more detail. But the Retail Leases Act, there are clear requirements and clear terms that need to go into the lease. And even if there's an inconsistency between the Retail Leases Act and what the parties want, the Act prevails, right? But more importantly, there is a disclosure requirement, say, under a retail lease that you don't have in a commercial lease. So you've got to issue what's called a disclosure statement. And that's a very critical document, disclosing key things like outgoings and detail of what those outgoings are, planned developments. Is there any cases before the Land Environment Court in relation to the property? Any special conditions? That's got to go, and that disclosure statement has to be served before the lease is entered into, and that's critical. That's one difference. And then the Act itself says that, say, for example, in a commercial lease, you might have a rent review based on the greater of 1 or 2 methods. You can't do that in the Retail Leases Act. And a commercial lease will have what's called a ratchet clause, which says if you do a market review, the rent can't go below what it was prior to the review. Retail Leases Act prohibits that. Often, and some of you who have worked with me over the years will know this, we will occasionally from time to time try to negotiate in a commercial lease that the market review happens before the exercise of option, because as some of you know, a lot of the time a commercial lease will say, yeah, exercise the option and then the market review happens. Well, the Retail Leases Act has a mechanism where you can bring on a market review before the exercise of option, right? Which is quite a good thing, because then you can then make a more informed decision as to whether you exercise your option or not.
Right.
And then there's other things. So, say, for example, under the Retail Leases Act, that if a tenant provides a cash bond, it has to be lodged with the Department of Fair Trading. If you get into a dispute about a market review, the Retail Leases Act sets up a whole mechanism to work out how to solve that dispute. And it's a lengthy process. Having been involved in them, in those sort of processes, it's quite lengthy. But it's there. It's all there to protect the parties, but I think protect the tenant more than anyone else.
Who drives the rental market review? Is it the landlord predominantly, or do you have to get an independent expert?
So it depends on what is in the lease itself. Some leases will have either the landlord or tenant can trigger the market review before the end of the term. Most of the time, the landlord triggers the market review. But then, if the tenant doesn't agree with that market review, that's where then there's a process for the tenant to then dispute it and have it independently assessed. And then and again, it's a lot more detailed than this. But there's a process where then, if the tenant doesn't agree with the independent assessment, that can be assessed again by I think it's like 2 appointed valuers. But there's a whole process which can happen, which you don't have if you have a commercial lease. But the short of it is, usually the tenant, so the landlord will trigger the market review, and then it's up to the tenant to then to then dispute it. And if it's a commercial lease, it's usually a whole lot of mechanisms put into the lease. If it's a retail lease, there's mechanisms, but they're subject to what the Retail Leases Act says.
Yeah. And do you think that the Retail Leases Act is geared slightly to more towards the tenant and the tenant's rights and trying to preserve those?
Yeah, I've got to be careful what I say, but
yeah,
in my experience, yes, it is. And that's why it was designed, for that reason, to protect the tenants, particularly where you have an unsophisticated small business owner or first-time small business owner.
Yeah,
it very much is set up for that. I mean, interestingly, if you look at the retail, your big shopping centres these days, they're dominated by brands which are generally got experience and got runs on the board.
Sophisticated.
Yeah,
absolutely.
Absolutely.
And it does sound like a savvy landlord or a landlord that gets good legal advice would be able to, put in the relevant protections following the Act to make sure that everything's done properly without any, trying to avoid those disputes with tenants.
Absolutely. But when in doubt, even if the documents aren't quite right, the Act prevails.
Yeah, absolutely.
So it's interesting. Yeah.
So you've mentioned a number of different key terms in a lease, and a number of those key terms that you said you would put in there to try and avoid disputes. Is there any sort of terms in the lease that govern disputes or the dissolution of a lease? Yeah.
So the good leases will have a dispute resolution clause within it, so that if there's and depending on what the provisions are that are in dispute, the first port of call will be a dispute resolution clause. And in fact, you often see those dispute resolution clauses more in, say, an agreement for lease, which is where, again, some of you out there have worked on these with me, where we'll get a premises built for us first.
Right.
And those can be rife for dispute along the way, whether it be missing deadlines, delaying delivery, disputes over the build. Yeah. You'll have a dispute resolution clause you can go to if the parties are in dispute, but they should also be in the lease. Bottom line is, I'll just say to my clients anyway, when a dispute brews, before I hand it over to Emma and my team, you got to try and resolve it, because, sometimes you can't avoid it. It's like catching a cold, getting an illness. You get into a dispute, you're going to have to go to the doctor, you're going to have to get that medicine, and sometimes that is expensive litigation. But what we try and do before that, it's hey, try and resolve it, work out a cost benefit of going into a dispute. And having worked that out, you then try and resolve it informally. And Emma, sometimes you can't.
Absolutely.
Then you go for alternative dispute resolution, which is mediation, which generally Emma's team will do. But I have over the years done plenty of them, and I find them quite interesting. They can be quite therapeutic for the parties, because often what happens is what was in dispute what these mediations bring out is something else that you have never even thought of, that is brewing there in the background, and they can be quite good. Other times they don't work, and if they don't work, well, then we end up in court.
Absolutely.
But we then not 9 times out of 10, but often they'll then be settled on the steps of court, or within 2 or 3 days of a hearing, they'll be settled in any event. But it might take going to court, or the threatening of court, or the issuing of a court document to actually get the parties real.
Yeah, absolutely. I think you mentioned earlier that even if you have a dispute resolution clause in your lease, which says that in the event of a dispute, you can go straight to court, under the Retail Leases Act, you have to go to mediation first.
Absolutely.
And you can't contract out. Is that right?
No, yeah. So you have to show that you have mediated it, and you have to get a certificate. Some people, and often I'm not, what I've seen happen, and I did a series of mediations during the COVID years, a lot of them, awful waste of time for people, horrible. But what some people would do is they wouldn't rock up to the mediation, but as long as you got to get a certificate from the mediator to at least show that you tried. the court will want to see that because I'm sure, and you've sat in court, I imagine, where the registrar or judge has said, they said, okay, get out of my court and go and resolve it informally first. Go to a mediation first.
Absolutely.
Don't waste my time.
If all parties turn up ready to have the matter heard, we can still be sent back to mediation if that box hasn't been ticked.
Yeah.
And there are often cases that a mediation does have a good outcome. Yes, the COVID years were very challenging for that process. But as we'll discuss, further throughout the presentation, litigation is expensive, and being able to resolve this through the Small Business Commission and mediation is often in everyone's best interest.
Absolutely.
To get on with the businesses they're running.
Because often litigation is a distraction. I say that with clients, it can be consumes your time. And often I'll say it jokingly to my colleagues, you come to me, your expectation of what legal process costs is based on a property transaction, but often, unfortunately, because litigation can be so labour intensive, by the time you get expert reports, examination of evidence, having a brief counsel, it can be crazy.
Absolutely. The costs can skyrocket really quickly.
Yeah.
But something you also touched on earlier was termination clauses in leases. And that's one big area I see in my practice, is where a party purporting to have terminated the lease hasn't followed the termination clause and the requirements set out in that termination clause. Did you have anything you wanted to point out
absolutely. So this is critical. So first of all, when we're negotiating the lease, we build in enough of and often landlords won't move on it, but enough of a buffer that before we should get issued a breach notice and a reasonable amount of time to rectify a breach. Now, often landlords, the most I'll give you is 14 days, right? But that's for any breach other than for non-payment of rent. And you're lucky if you can get any buffer in to rectify non-payment of rent. And that is because under the Conveyancing Act in New South Wales, so the main pieces of legislation which govern property law in New South Wales is Real Property Act and Conveyancing Act, besides Retail Leases Act for leases. The Conveyancing Act has a clear regime, and it says that you have to give, you have to issue a notice before you can terminate a lease when someone's in breach, and there's actually a strict format to follow. So what you have to do is you have to issue them with a breach of notice and say, you have to rectify the particular breach within a reasonable time. And we say the reasonable time is X amount of days, and there's a bit more science to it than that, and a bit more formalism than that. But it's not necessarily 14 days. It's whatever the reasonable time is. So say if it's to fix something that's repair something that's damaged, the tenant has caused it, 14 days might not be a reasonable time. It might be 28 days.
Yeah.
But non-payment of rent, you don't have to issue any breach notice first. So if a tenant is in default for non-payment of rent, you can lock the landlord can terminate the lease. Now, what they can do, they can either terminate the lease and issue them with termination notice, or they can go in the middle of the night and change the locks and retake possession. I've seen both happen.
Yeah, absolutely. We'll cover the relief that tenants have available to them shortly.
Yeah, I just want to add that. And that's the thing.
Yes.
I say to clients, I know you can probably do that for non-payment of rent, but do it at your peril, because we've seen many cases on relief against forfeiture. And often termination is not the first remedy as a landlord that you should pursue. It might be, first of all, and it should be, calling on the bank guarantee or security you may have first.
Yeah,
and then the mechanism is then usually, and I'm generalising here, so don't take this in every case you do, but then you request a replenishment of that security, and there's a security cannot be replenished. Well, that's a breach notice there, provided the security is sufficient to cover the particular breach.
Yeah, absolutely. So that regime that you discussed with breach notices in conveyancing, it's a similar regime in leases?
Well, that is for leases. That's for leases.
Okay, sure.
Conveyancing a bit different.
Slightly different. Okay, we'll get to that. My apologies.
No, that's fine.
So what I find with breach notices and people coming to me wanting to question the notice that they've been served is the form that the notice takes. So it really needs to clearly identify the breach with reference to the terms of the lease.
Yes.
It needs to identify whether the breach is a material breach or a minor breach, because some minor breaches don't give rise to a right to terminate.
Absolutely.
And some landlords may choose to terminate on a minor breach, and that causes some difficulties down the road. And it's also important to make sure that that breach notice gives the other party a clear opportunity to rectify that breach before terminating. So while you don't have to send a breach notice, as Andrew said, for non-payment of rent, best practice probably is to do some form of communication to say, you're not paying your rent, why not, before you go straight to a termination notice. Because as Andrew said, there's a lot of other mechanisms available to try and resolve this without taking the nuclear option.
Absolutely, because of the risk, this relief against forfeiture is a really scary remedy that can work against the landlord if you're not careful, and the consequences. One thing, Emma, you were saying, and I've spoken to your team before about this, even the way you got to serve that notice.
Yes.
So in this day and age of emailing, you might think you can just email the termination notice, but unless the lease, and if you've got an older style lease that might not allow for service by email, even though the Conveyancing Act now says there's reference to allowing service by electronic, but unless the parties have clearly agreed on that, then you could have a defective breach notice if you've served it, say, by email. What's your view on that, Emma?
Yeah, look, absolutely. I think if the parties have agreed to it within the lease and there's some acknowledgement once the breach notice is being served. So, for example, you send the breach notice to the party and they write back saying, thanks for your breach notice, we're going to rectify, or thanks for your breach notice, we can't rectify, or some acknowledgement of it. That will give that should give you some certainty that they've received the breach notice. The difficulty we've got, of course, with electronic correspondence is, yes, someone may have nominated this email address at some point when signing this lease, but is that email address still monitored? Is it still active? Is it still coming to the party's attention? And that's really the key thing. Best practice would be to send these sorts of notices by other means other than just electronic.
Like hand delivery. You can even get process service.
Absolutely. For a minimal cost, someone can personally serve it on the person that needs to have the attention brought to, and that is best practice.
And we've had some clients where there's no one there at the premises, but you just got to find their...
Absolutely. Like you said earlier, you deal with dirt. If there's no structure on the property and you don't have anywhere else to serve a notice, what do you do? And that's when you start having to dig into where the parties to the lease might be located other than the actual premises.
Registered office.
Absolutely. Yeah.
And what I try and do actually when we're negotiating the leases is we have an address for service of notices, and we will put in a specific address. But then what we'll say is, or as notified from time to time, or from time to time. So really, if you are landlords and you're managing a property portfolio, you make sure you are updating your tenant on your address. But if you are tenants, you should be, if the key person has changed, then you need to be updating your landlord to let them know that.
Yeah. As a general rule, if you've got a lawyer preparing your lease, would you ever use your lawyer's address?
It's funny, in this day and age, it doesn't happen anymore. So in the older leases, it will say it can be notice, it'll have a section for landlord and tenant. It will say a valid notice is served validly if served by the party's lawyer. So I'm just looking at some questions already coming up.
Absolutely.
Lawyer, agent.
Yeah. Accountant.
But that is happening less now. It's usually, particularly in the corporate space, it'll be the CFO, in-house chief legal counsel, whatever.
Absolutely. It's a much more sensible approach to have to serve it on the actual party and not on a service provider to that party that may move on over time.
Absolutely. And I have some clients who have like a separate property department address for property, like issues to do with property maintenance versus payment of money.
Absolutely. And big organizations would have to have that to be able to monitor their incoming communications.
Absolutely.
Yeah, absolutely. Okay. Well, as we were discussing earlier, relief against forfeiture is the most common relief sought by a tenant when bringing a claim against a landlord. The key things here to consider are that if the tenant is able to remedy the breach, the landlord is able to be placed back in the same position as if the breach had not occurred, And the key element, that it would be unconscionable for the landlord to insist on the forfeiture of the tenant's rights, it is likely that the court will allow that relief. Now, there are some exceptions to that, of course. If the breach was for unpaid rent, for example, which it commonly is, a tenant is, and the tenant is unlikely to be able to pay the rent in the future, for example, some sort of an insolvency event or something along those lines, and the landlord can demonstrate this to the court, then a court may refuse the relief sought. Also, if the breach is severe and persistent, so happening over a long period of time, paying rent some months and not other months, for example, over extended periods, or the tenant has allowed the property to fall into disrepair and failed to make any good. Those are the most common things that we see. We haven't touched on make good.
Yes.
Do you want to maybe explain slightly what make good is?
Yeah. And can I just go, and can I go back in the context of this relief against forfeiture as well?
Absolutely.
Before you go ahead and if you're a landlord, you want to lock your tenant out, the one thing I'd probably say is, and it comes in the context of make good.
Yes.
So I'll have some clients that, will say, oh, this tenant's really difficult. They're really hard to manage. They don't pay, look, I just want to end this. They're not paying their rent. They're constantly behind. But often one of the downsides of that is, particularly if you go and you retake possession and the tenant has left behind all this stuff. Like I've had one I'll never forget once where there was this client that wanted to retake possession of a place that had a whole lot of car parts, spare parts, right? You got to work out who owns them. And you can't just, you think as a landlord, you'll just go and sell all that stuff.
No, you've got the abandoned goods notice process.
Right.
And it's all very prescriptive by legislation.
And believe there's charges on those goods. Someone's
Absolutely.
got claims on them. So that's why terminating a lease can be an extreme act. And I'll add in there about termination as well. The other one now, another one, it's an aside, but I thought I'd raise, is under the new tobacco, there's some new tobacco laws coming in, and there's all these rules around vaping, about illegally selling vaping and legal sales of vaping and tobacco. There's some provisions now which allow a landlord to terminate a lease legally if there's a bit more to it. I won't spend too much time on it today, but if a tenant gets a shutdown notice from the Department of Health, the landlord is able to terminate a lease. There's a certain period of time the notice they've got to give, but the lease can be terminated, and it's like the lease comes to an end.
Okay.
Right?
Wow.
Yeah. So that's an interesting one, but
that will be an interesting space for disputes moving
forward.
Yeah,
very much so. But there's going to be obligations on landlords as well, which haven't quite been. There's a bill before Parliament hasn't been passed.
Right. Well, we might do a further presentation
that would be a good
on
one
that once that comes out.
But failure to make good, that's a massive issue, and I see a lot of these, and you'd be like, it wouldn't be every couple of months we'll go by where a client will come to me and say, Andrew, yeah, I negotiated my new lease that I'm moving into, but I haven't sorted out my make good. There might be 2 or 3 months to go before the end of the term, and they're trying to sort it out. Make good is a massive area of dispute. And the reason it's a massive area of dispute is because, first of all, often the leases have fairly general clauses on what make good means.
Absolutely. Parties
may have taken a condition report 10 or 15 years ago when they went in and the premises didn't keep that report. Or there are elements of, we might agree on the criteria, but we don't agree on how. So, for example, I'm looking in this room we're in now, right? The lease might say the tenant is to repaint the wall, but it might say in the colours approved by the landlord, or it might say 3 coats of paint, but it doesn't say, and the quality and standard the landlord requires. So what does that mean?
Yes.
So what or it might say you need to remove your racking, but it doesn't say shave the bolts to ground level versus core hole drilling. And there's a difference of about $25 a bolt. And the last time I looked at it in cost, so imagine you have a massive warehouse.
Absolutely.
Or there's all sorts of things. And so, and so what I first of all recommend, again, at the time the lease is being negotiated, really drill down as much as you can on what make good means.
Absolutely.
Keep a condition report at the start of the lease, so everyone's clear on what the condition was like when you first went into, because 9 times out of 10 a lease will say you got to return it to the way you found it.
Absolutely. But if no one can prove how they found it, then what do you do? And we have a lot of disputes based on that. What was the condition when we moved in?
Yeah, and so then often the negotiation will be, okay, who signs off on that condition report, who pays for the cost of that, but it's a critical document.
Absolutely.
And then if you're coming to the end of the lease, if you know that you're leaving the property at the end of the year, don't leave it until, because I've seen this happen, October or November to negotiate. Probably start that conversation at least 6 months or 9 months in advance. And that becomes a question of whether you're going to do the make good yourself or cut a check to the landlord. And if you're a landlord, whether you're going to worry about dealing with a tenant to get their make good done or just receive a check. Well, actually, there's not checks anymore, but you know what I mean. So I'm showing my age. But the point being that because often what I see some tenants do, and I've seen these cases where this happen, where tenants try and do the make good themselves without consulting with the landlord or not hitting an agreement with the landlord on what needs to be done. The landlord then says, tenant says, hey, here you go, Emma, here's my keys, see you later. Landlord then, you get a letter, hey, you didn't do A, B, and C to our satisfaction. We're going to do it, and we're going to charge you for it. And we're going to then recover also the lost rent that we could have earned while you were doing what because your make good wasn't finished. Someone's just said a question, a very good question about fair wear and tear. What does this really mean? Okay, so this is a very, very layman's term to describe it, but probably because there is so much discussion about this. You get so many experts, and you could probably give your view.
So much case law where this has been debated at length.
So I want to say the layman's terms. If I say this room I'm sitting in, the carpet, the fading would be fair wear and tear. But if there were holes in the carpet caused by this chair, that's damage. The painting of the wall, which is not a good example because often you have to repaint, but say if you didn't have to repaint. Fading.
There's a scuff on that wall, that's fair wear and tear. If there was a hole in that wall, that would be damage.
Yes. And so what was just some of the cases you've got involved in?
Oh, look, a lot of things at the moment dealing with concrete and permitted use of leases with heavy machinery on concrete. So when you go in knowing you're going to have heavy machinery on concrete, and the concrete slab is being poured in a certain way, you then have to get concrete engineers in to work out whether it's being structurally sound, and is that fair wear and tear when they knew that it was a permitted use, that heavy machinery would be on the concrete pads. Is that fair wear and tear if there's some slight cracks in it in places, or is that damage caused by the use? That's one case that I'm dealing with at the moment.
And this is why if you enter a make good dispute, it is so difficult.
Absolutely. And
you're better off trying to sort it out and settling it. Sometimes it's not ideal because a landlord then has a cash that you've given them, and it may not cost them what you pay them, for example.
Absolutely.
But far better that than the cost of getting into this debate about is it fair wear and tear. I've got another question. Removing racking bolts from floor, appropriate finish. Yeah. So where tenants get caught out is where it will say, for example, the lease will say the tenant must restore all surfaces or not just repaint, but retreat all surfaces.
Yeah.
So that would include if you've got a concrete floor, having to apply epoxy resin, for example. And with bolts, if you remove the bolts, it will mean fixing the damage caused by the removal of the bolts. So it will become a question of what is in the lease. And so that's why at the start of the lease negotiations, you try and put some of that stuff in there.
Yeah, absolutely. We could do a whole session just on make good.
Yeah, absolutely.
But we've talked now about leases falling over. Conveyancing disputes seem to escalate much faster. Why is that?
Because the timeframes are often more compressed. So the two sort of things that I see happen often. Say 3 weeks before settlement, the tenant comes up with a problem in the property, a defect, and the other one which happens, and it happens purely when interest rates start going up, the purchaser will suddenly say, oh, we're not ready to settle because our finance has fallen over. And we've seen that happen. They're the sort of
Finance delays, absolutely.
They're the big areas.
Yeah, definitely. Once the completion date is missed on a contract, things tend to unravel very quickly, I'd imagine, in your practice.
Yep.
What's the most common issue that you see that turns a straightforward sale or purchase into a dispute?
Yeah, it is that. So say, for example, and I've got various war stories about these, where I've acted for either a purchaser or a vendor. So, you know, the stock standard conveyancing transaction, you have a 6-week settlement. Where we go to be, you know, I'm acting for a vendor, the purchaser will, and the way it works these days, we go into the PEXA workspace and we're all ready to settle, and the purchaser doesn't complete on that day.
Yeah.
Now, at that point, the vendor, depending on what the contract says, but generally speaking, the vendor will have the ability to issue a notice to complete to the purchaser, and it says if you don't settle in 14 days, we then have the right to terminate. At that point, usually penalty interest kicks in. Conversely, you could have a situation where a vendor is not ready to settle on the settlement date, and that's usually if, say, for example, the vendor, I don't know, they could be waiting to move somewhere else.
Absolutely.
Or and that property isn't ready because who they're purchasing isn't ready to settle. Or where, and I've seen this happen, and I'm doing a presentation tomorrow on this, where the vendor, for some reason, doesn't puts vacant possession on a contract, but they haven't correctly terminated the residential tenancy. And under the new residential tenancy regime, there are strict and usually long timeframes. So say, for example, if, for example, the rules say you can give the tenant 30 days notice after you've exchanged contracts, but it's the later of that or the date that the lease comes to an end. If the lease comes to an end 6 months later, you got problems.
Absolutely.
Right? And so it becomes a real issue of then, what do you do? You know, like, do you terminate the lease? Terminate the contract, rescind the contract.
Yes.
And then do you pursue legal action, or what do you do? And this is sort of what your world a bit, Emma.
Yeah, absolutely. Look, having the right to do something and exercising that right wisely are two very different things. It's often not commercial to pursue some sort of outcome in court on a contract. If you're a party to a contract and vendor, obviously you've marketed your property, you want to sell your property. That's the ultimate outcome of the contract. You want to sell it. A purchaser wants to buy your property. Of course, there are a lot of nuances to having delays caused by financing, but if you know, or financing or any other delay, but if you know there's going to be a delay and you communicate that to the other party early, they're going to be much more receptive to agreeing to extensions than the day of settlement. You're on the phone and you're saying, PEX's settlement was at 2:30. Why haven't you signed off? And then it all becomes apparent as to why there is going to be a delay. And people have got things planned. The vendors plan to move out. The purchaser may have planned to move in. It's it's much cleaner for everybody if you communicate it early.
And there's that, and like in theory, so I'll say to my vendor clients, well, you can potentially recover the deposit plus the loss, because if you were selling it for 1.6 million today and you can't get 1.6 million in a year's time, you could potentially sue them for the difference.
Yeah, absolutely.
But often I say to clients, by the time you pursue that, you're just far better trying to just get it sold to somebody else and remarket it.
Absolutely, because to claim damages or to be successfully able to claim damages, you must prove actual loss, causation of that loss, and that you try to mitigate that loss. There are so many steps in proving a damages claim that becomes very complex, very expensive to prove, and it's hotly contested by the parties. So it's not something that will just be accepted, that you are entitled to damages. Vendors want, normally in my experience, vendors want some certainty, speed, and a clean exit. And the commercial reality of litigation is that you don't get that.
The other one that comes up is the other two things, the areas of is that not settling, but we're ready to settle, but we come up with some defect in the building. Right?
Absolutely.
Now, there are clear obligations on a vendor to disclose. There's prescribed documents that need to be attached to a contract, but there is also an obligation, depending on what it is, to disclose. So if you know there is a defect, you disclose it. If you know there's something wrong and there's an illegal structure on the property, you disclose it. That way the purchaser can't say you didn't tell me about it, because there's provisions even for agents in disclosing any material aspects of the sale.
Yeah, absolutely.
But if there is something that comes up, like what I call a claim, there are mechanisms in the contract which deal with that. And so, for example, there's an ability in the standard New South Wales contract for a purchaser, if they make a claim above a certain percentage of the sale price, the vendor has the ability to say, well, if you don't withdraw it, we're going to rescind, or there's a mechanism to say we're going to quarantine an amount of the purchase price in trust to sort it out. Often what happens in practice is we actually would negotiate that to agree to put some money aside until the problem is sorted out.
Yeah.
And the standard contract has an ability for an expert to come in to work that out, and you basically live with the umpire's decision.
Yeah.
But that's an area and the other one is often when, particularly in commercial matters, or I say it sometimes in farming properties, where the vendor doesn't get rid of their junk that they said they were going to get rid of by settlement.
Yeah,
And
absolutely.
so I talk to clients a lot about making it clear.
Yes. I've had to call agents more than once to say, have we cleaned out that shed before we can complete on PEXA? So it's absolutely important. And if you're agreeing to sell your property having removed all of these things, you need to remove all of these things before we can complete.
I had a matter the other day where this came up, and the other lawyer on the other side said, I'm making for a purchase of the vendor. They said, well, vacant possession, it assumes it's going to be empty and we're trying to negotiate a contract. I said, I don't care what it assumes. I want it listed what you're going to do. And particularly if it's a commercial property, if you're going into a property and expect vacant possession, I think it's important, almost like a make good type clause, to actually say what you expect it to be handed over like.
Yeah. And as a disputes lawyer, something like that, a regime like that in the contract where it's clear and detailed, it's brilliant.
Yeah, it's critical.
Absolutely. The other thing to just keep in mind with communications about delays or anything during the completion period is that your conduct isn't considered repudiation. So you want to make sure that what you're doing is trying to resolve and settle the contract and not repudiate from the contract. Yes. Did you want to talk about that?
Yeah. So it's not about we're going to rescind or we're withdrawing. It's more around extension of time.
Absolutely.
That's got to be the language.
Yeah, it has to be clear that it is, we will settle, we want to settle. We're not saying we can't settle. We're not doing anything to endanger the validity of the contract and the fact that we want to complete it, but we just need more time.
And if you are a vendor, you need to be, before you issue a notice to complete, you need to be ready, willing, and able to settle. And that means making sure you've got your ducks in a row with your outgoing financier who needs to provide a discharge. It means making sure you've got a clear land tax certificate, for example, or made your arrangements so that you'll get clear land tax on settlement. I think those things, and the other thing I was going to say, if you're a purchaser, if you know you're going to have problems with your finance, trying to negotiate a subject to finance clause would be great. A lot of vendors say, no way, go jump. But don't sign on the dotted line until you know you've got your finance sorted, because the consequences could be severe.
Yeah, absolutely. So we've covered leases and we've covered conveyancing transactions. But Andrew, as you know, we work quite closely on security enforcements.
Yep.
So when the vendor to a contract is the lender selling pursuant to its rights as a mortgagee or a judicial order of sale as a lesser security holder, the conveyancing landscape takes on a whole different tone. Yes. The biggest area, what are the types of clauses that you would put into a contract if you're selling, if the vendor, you're acting for the vendor and they're selling as lender.
Yeah, so I make it clear an acknowledgement of that, first of all, of that fact. And then I would try and negotiate as much as possible and require a minimisation of liability, because at the end of the day, the lender is only selling it in their capacity of their as enforcing a security. So it's not like they're your normal vendor, so that their liability has to be minimised.
Absolutely.
That it's almost like similar to when we're acting on an appointment of an actual official receiver, or where we're acting where we're dealing with executives of estates.
Yeah, absolutely.
So that is the biggest thing we need to do. Other than that, we have to do this. We act in as if the lender is the owner.
Yes.
Because we have an obligation, and you'll touch on this no doubt, an obligation to the actual real vendor, who's the customer, to maximise and the asset and do the best possible job we can.
Yeah, absolutely. Earlier I mentioned a mortgagee sale process or a judicial sale order. So just touching on that for a moment, while the most common form of security that a lender might get to register on title is a mortgage, and if you have a mortgage, then a lender has a clear process to follow when exercising its right of sale that's set out in legislation. There is another form of security, which we're seeing more and more from non-bank and private lenders when they loan money, which is a right to caveat. So a lender that registers a caveat can still exercise its power of sale, but it's not an automatic right like a mortgage. So a caveator would have to approach the court first to seek a judicial order of sale. And then usually if there's a mortgagee on title, they would have priority, and they would not normally allow a lower priority creditor to control a sale process. But as we've both seen, that's not always the case. Sometimes if a mortgage isn't in default, for example, the mortgagee may allow an inferior or a later priority to go and sell the property. But in both cases, whether you're selling it under a judicial order of sale as a caveator or a mortgagee, you have to have specific clauses and inclusions and all those sorts of things in contracts. Yes. You touched early on having the authority to sell and making sure that you've got the appropriate limitation of liability and those sorts of things. Is there anything else?
Yeah, so other little other key things. Like say, for example, and it's more of a practical thing. So say when you sell property, the vendor needs to provide a certificate. It's a foreign resident it's
foreign withholding capital gains tax.
There's an abbreviation which I can never twist my after all these years, but effectively it means that if you don't produce this certificate, the purchaser withholds a percentage of the purchase price aside.
Absolutely.
Now, but what happens, and we've seen this happen, where the purchaser, that's where the certificate's got to come from, goes missing, and we can't get that certificate from them. Or sorry, where the vendor goes missing, and we can't.
Yeah. So the borrower. Goes
missing. So in that situation, there's a different certificate we need to obtain. You can get it still, but it's a different process.
Absolutely. And the lender then has to go through that process.
Correct. So that's an example, and that's a typical example. When we go to settle and we do our settlement numbers, there's a lot. It's a bit of a different focus, where we have to work out this is how much money we've got, and these are all the different people that need to be paid out.
Yeah, absolutely. And that's so important because of the duty of care that lenders or controllers have to borrowers when selling property. So in my practice, when we take possession of a property, I often get calls from borrowers saying, please don't sell my property. Please give it back to me. The bank's just going to sell it as a fire sale. They won't get the best value of the property. And what I have to remind, or what I let the borrowers know, and whether they accept that or not is a different issue. But there's a statutory duty of care that is imposed on all controllers and lenders when they're selling the property. And that duty of care is to ensure that that they take all reasonable care when selling the property to ensure it is sold at not less than market value or the best price that is reasonably obtainable, having regard to the circumstances existing when the property is sold. So what that normally means is that if you have run a particular campaign and you can document the campaign that you've run, and you've really tested the market, you've got a valuation, and then you're not looking to sell it for much less than market value, you would normally have discharged that duty of care. However, it's quite objective and can cause some difficulties. But I have got clients that take that duty of care so seriously that they'll pass properties in at auction if they're not reaching the market value, and they'll test their process and say, well, what did we do here? Is our valuation too high? Is there no one willing to buy this property for what it's valued? It's not always about just trying to recover just enough to repay their loan. And a lot of borrowers don't understand that. So it's a really important part of the security enforcement process, is that everyone needs to be aware of this duty of care, and it can cause some major disputes if it's not adhered to. And to your point, that's why the settlement statement and the accounting that's done at settlement is so important, to be able to justify all of the costs that have been incurred and gone into the process if anyone ever complains about it.
Absolutely, and so I suppose the bottom line is, we probably, you when you're acting for a mortgagee sale, it is the same duty that you would apply if you're acting for the lender anyway, right?
Absolutely.
The other thing I want to add to, because I'm just looking at our time, we've probably got about 9 minutes.
Yeah.
Is caveats. How you mentioned caveats.
Mm-hmm.
So I just want to, because that's my bugbear at the moment. I'm seeing a bit of this where people think, particularly those that say have lent someone money with some sort of loose loan agreement, and then say, I'm going to lodge a caveat on title.
Absolutely.
That I just don't think it's easy as is going to whack a caveat on title, for two reasons. One, there are specific requirements of what must be in a loan document in order to support the lodging of the caveat. Number two, if you get it wrong, you end up in the Supreme Court, you'll know it.
Absolutely.
I will say to clients now, because we as the lawyers have to do the certification on the PEXA website, PEXA workspace, about that we believe this is correct. I'll say it. Look, I'm sorry, I don't think this is right. I don't think this is your best. And sometimes a caveat is not your best remedy. It might be an injunction.
Absolutely.
Or something else. They're all expensive processes, but that's the risk you take if you advance money to someone and you don't get a second mortgage registered at the start. Yeah, that's what happens.
Yeah, and if you lodge a caveat wrong, that's expensive to fix as well.
Yeah,
and someone will seek to have that withdrawn. So, and it's not as easy in a loan document to say there's a charging clause. It needs to be specifically worded to support the intention of the parties. So that needs to be made clear.
Do you want me to answer this question first, or do you want to do the wrap up first?
I think there's some earlier questions too, but you can answer this question if you'd like.
So this is guidance on making demands on rent, informally, and how it can impact the landlord's ability. Yeah, so you've got to set it up. So you want to have, because in case a tenant, and I'll get you in a minute, Emma, to chime in here,
sure.
But because you run that risk of relief against forfeiture, you want to set it up so that you've had, and it goes to the court of equity.
Mm-hmm.
They talk about clean hands. So you want to make sure that you have done everything you can in your power as a landlord first. So you issue a letter of demand. You issue an invoice first.
Yes.
Then you do several chase-ups.
Mm-hmm.
Then you say, like if you're not going to pay this, we're going to call on the bank guarantee first, or security first. Mm-hmm. Then if you don't have sufficient security, then you go down the track of the a breach notice.
Mm-hmm.
Then you decide whether you want to. And just because you issue a breach notice, by the way, you don't need to terminate or lock the tenant out. You just got it there in your back pocket.
Absolutely. It's so important to make sure that you're having discussions earlier. It's going to be much easier for you to reach a resolution quickly and efficiently if you have a tenant that is not paying their rent, and do you send them a letter, or you pick up the phone and say, is there a reason why? What's going on? Let's have some commercial discussions here. There is normally a resolution that can be had. if you can't reach the tenant, if they've abandoned the property, and there's lots of other factors, of course, but
if they've abandoned it, well then they've repudiated it, right?
Absolutely. So that conduct is
although that then becomes a whole other issue of dealing with the stuff in there.
Absolutely. So I don't know if Charlotte can take us to the earlier questions, if you wanted to do the earlier questions.
Yeah, I can do that.
Sorry, everyone. I don't have control of the...
Yeah. I did see some ones. I thought I saw something about CPI earlier.
Yes.
So
maybe Charlotte can read that to us.
Yeah. So market review v CPI increase. How is the market review obtained? Who completes and decides on the value of the increase? And then how is the decision made which review increase is used between market or CPI?
So, okay, so CPI will be, it will depend on what the lease says. So the lease will usually say whether you can use a CPI or not. And if the lease doesn't allow for CPI, you can't use it. And just be clear with CPI increases, whether it's like it might say Sydney all groups, or it could say Adelaide all groups or whatever. And it's usually, you don't get that headline inflation rate of 5, 4, 3, or I think they're talking about 5% now. It's you have to do the calculation of the percentage change quarter by quarter and use the index number, right? But a market review, I think I alluded to this before, it depends on how the lease is drafted as to who can initiate it. Sometimes it's the landlord first, and then the tenant has a right of reply. And then if the parties don't agree on the number, it then has an independent valuer appointed. And there's usually, like from a body, it's usually, from the governing body of valuers or the law society or something like that.
Yeah, absolutely. And a lot of leases I've seen recently have allow for a CPI increase during the term of the lease, but then they require a market review on exercise of the option. So that's also, you've got to be careful that you're not just relying on a CPI increase the whole way through if they exercise the option.
And don't assume that a CPI increase is a market review, right? Well, the market review will align with the CPI, because there's other criteria that will come into a market review. And again, that's usually done by a valuer, but there might be criteria like rents of comparable properties, for example.
Yeah, absolutely.
So there's a whole science to do with valuations.
Yeah, definitely. So just to wrap up, some key takeaways from today that we were hoping you would walk away with is that most property disputes are created by process failures and not bad intentions. It's not normally the parties' intentions that cause the disputes. Early disciplined intervention prevents escalation and preserves leverage. So that's the early communication, early discussions, what we recommend is that you should draft and act as if the deal will be tested, because it often is. So Andrew's example earlier of, vacant possession, what you're actually going to take and leave behind, so that's clear and the parties have a basis on which they're contracting. If you draft it appropriately, assuming it will be tested, that is the best approach.
And often I'll say to my clients, landlord or tenant as well, at the start of the deal, if things are really difficult when you're just negotiating commercial terms, you may reconsider doing a deal with them, because you're going to be stuck with them for a 3, 4, 5 year, 10-year period.
Yeah.
And if it's difficult at that point of the initial negotiations, what is it going to be like when a real problem happens, like a torrential downpour and it's leaking?
Absolutely. 1 in 100-year water event. Absolutely.
So it's almost because like you're stuck in this tenancy relationship, particularly. Yeah. So you've got to be comfortable with the people you're dealing with, and if you're not, don't go ahead with it.
Yeah, absolutely.
And that's not a legal takeaway. So that's not a legal point, but it's a practical point I think you should really consider.
Yeah, absolutely. So thank you for joining us today. I think we'll give you a 1 minute early mark so you can stretch your legs before returning to work. Thank you very much. If you've got any questions, please reach out via our email addresses.
Yeah, feel free. And thanks again, everyone, for attending.